myself included, were left completely in the dark about the extent of the NSA's data mining program, and I worry about the balance between legitimate national security needs and the constitutionally protected rights of all Americans. The government is stockpiling sensitive personal data on a grand scale. Intelligence officers, contractors, and personnel only need a rubber stamp warrant from the FISA court to then learn virtually everything there is to know about an American citizen. The American people have a right to know about this program and, at the very least, know that such a program is operating within our system of checks and balances. I believe Congress has a constitutional obligation to protect individual privacy rights, and I believe it's time to re-examine the Patriot Act, insert greater accountability into the FISA court, and ensure that our laws cannot be interpreted behind the backs of the American public. With this hearing, this committee has begun this important work of oversight and repair, and I thank the chairman and the ranking member for calling this hearing. I thank the witnesses as well for participating. Mr. Cole, I want to ask you about the October 2011 letter sent by then Assistant Attorney General Ronald Weich to Senators Wyden and Udall regarding Section 215. The disturbing information that Senators Wyden and Udall learned, however, was classified and was thus kept from the American public and even most members of Congress. Now, Mr. Weich seemed to imply in his response to Senators Wyden and Udall that because Congress, or at least a select number of members of Congress anyway, received intelligence briefings in accordance with the Patriot Act, that there's no cause for alarm that the government was using some sort of secret law to expand its surveillance activities. Now, the Patriot Act was passed in response to the horrific attacks on 9/11, designed to bolster national security by expanding the investigative techniques used by the government and law enforcement officials to hunt down suspected terrorists, something that we all agree is important. But Section 215 had a standard of relevance, and there had to be concrete information linking a person to a terrorist organization before the NSA could secure that person's information. Instead, what we've learned is that the FISA court has essentially rewritten Section 215 to say that any and all persons' records may be considered relevant, therefore allowing the NSA to indiscriminately collect sensitive data on all Americans. The fact is, in 2012, the government made 1,789 requests to conduct electronic surveillance. The court approved 1,788. The government withdrew the other. Now, as a member of Congress who was not privy to those intelligence briefings, I had to accept Mr. Weich's assurance that there's no secret law. But in the aftermath of these recent leaks, however, it seems that there may be secret laws. Laws not passed by Congress, laws not publicly interpreted by the Supreme Court, but rather secret laws born out of a classified interpretation of the Patriot Act by the FISA court. The New York Times recently reported that the FISA court has quietly become almost a parallel Supreme Court, serving as the ultimate arbiter on surveillance issues, I would point out, with only the arguments of the federal government alone to be considered. Now, even a former FISA judge has come forward with concerns that the body has become a de facto administrative agency, which makes and approves rules for others to follow. Now that it's become public that FISA courts have broadly, perhaps even unconstitutionally, redefined the relevant standard in Section 215, is it still the Department's position that the government isn't essentially operating with a secret playbook?
Mr. Deutch, I don't think we are operating with a secret playbook. There is, again, as we've discussed in many instances in our hearing today, the tension that exists between maintaining the integrity and the secrecy of some of the national security investigative tools that we use and making sure that people know about it. We have, in the course of the reauthorization of the Patriot Act on several occasions, done classified briefings, made individual.
Mr. Cole, I'm sorry to cut you off, but I only have a second left. Let me just broaden the question then for a second, because I'm speaking about these decisions that the FISA courts make as the supreme arbiter of this law. And stepping back for a moment at a more basic level, does the panel understand why the American people may find this revelation shocking, that secret court rulings could expand the powers of the federal government beyond perhaps what was originally authorized by law, and that an entire chapter in our laws is being written outside of the three branches of government altogether?
I think, again, this is an area where we are looking to see what kinds of opinions from the FISA court we can make public, These are things that we are trying to do and trying to go through. All significant opinions and all significant pleadings that have been filed with the FISA court are made available to the committees, to the Intelligence Committee and the Judiciary Committee, so they can see them. We're not trying to keep them secret. We're just trying to maintain the classified nature of some of these. But these are issues that we're trying to grapple with and trying to determine what we can let out so that we can have this broader discussion.